the hour. Welcome back to Court TV Live. I'm Ted Rollins. This morning we've been rolling out testimony from the Carol Hignite trial out of Kentucky. We'll have more in just a bit, but first, major developments in the Doomsday cult case. Lori Vallow Daybell says she has an alibi for when her children were murdered and when her husband's first wife died. Her defense is also considering working with her husband, Chad, on a possible plea deal. The couple faces first-degree murder charges in the deaths of Lori's kids, JJ and Tylee Ryan, and for the death of Chad's first wife, Tammy Daybell. In newly released court documents, Lori's defense states she was not present when the children were murdered, saying, quote, Lori Vallow was in her own apartment in Rexburg, Idaho, when JJ Vallow and Tylee Ryan died in the apartment of Alex Cox in Rexburg, Idaho. Defendant was with Melanie Gibb, David Warwick, and/or Chad Daybell. As for the murder of Tammy, Lori also claims she wasn't there. The document says, quote, Lori Vallow was in Hawaii when Tammy Daybell died at the home of Chad Daybell in Salem, Idaho. Defendant was with her friend Melanie Boudreau and Audrey Veritario. Joining us now, Joe Richardson, trial attorney and law professor in Los Angeles. He's been with us this morning. And Joe, this is a proactive move from the defense here, and it has, they're basically supplying an alibi defense. Is this a true alibi? Because if you look at the logistics of the Rexburg, Idaho apartments, Alex Cox has an apartment right next to or across the street from Lori Vallow. So, okay, you weren't in his apartment, but you were in your apartment, and your son was there a few minutes before presumably he was killed. Is that an alibi?
Well, there's certainly a hope that it is, right? But it is kind of ironic that you basically have a, quote, alibi that still all but puts you at the scene. So, that's certainly not my idea of what I would say is an ideal alibi. I was in another state. I was in another place. I couldn't witness it. I couldn't be part of it, et cetera, et cetera. So, it is interesting to see how much mileage she gets out of making the claims that she is. She's got to jump through her hoops, give the notice of alibi, press certain buttons under Idaho state law. But what she's hoping is that this allows her to be in the game to get a plea deal and maybe, gets her on the street one day, or keeps her from having the most severe punishment or that type of thing. But it has to look like to the prosecution that it's potentially exculpatory. My sense is I don't know that this is not something that they wouldn't at least see coming or at least know how to refute. So.
Yeah. When JJ was last seen, Lori's friends were in her apartment in Rexburg, Idaho, and Melanie Gibbs was one of them, and Melanie Gibb had her boyfriend at the time, David Warwick, was also present. Both of them testified at the prelim. Take a listen.
The recording of that podcast.
I did not see him.
Okay. Did you see Alex Cox that night?
Yes.
Okay. What did you witness, or what did you observe Alex Cox doing that night?
He brought JJ into the house during the middle of the podcast.
Okay. And did you see him bring JJ into the house?
Yes.
Okay. How did Alex Cox bring JJ into the house?
He carried him in.
Did you talk to Lori about JJ that morning?
I did.
What did she tell you about JJ that morning?
She said that he was being a zombie and climbed up on the cabinets, climbed up on top of the fridge, smashed her picture of Christ down, and then climbed up onto the upper cabinets and got between the top of the cabinet and the ceiling.
Okay. And then what did she tell you?
I asked to see him, and she just said that he was out of control, so she had Alex come and get him.
And
the other part of this equation here, of this latest filing, also has a request from Lori to be able to confer with Chad saying, quote, Lori and Chad would like to be able to talk together in person and on the phone about their options. The attorneys for the parties will attend any in-person meetings and phone conversations, but will not record the conversations and will not use the conversations as evidence. Joe, is it reasonable to allow two defendants who are being tried together to have open communication lines in terms of strategy going towards trial and possibly coming up with, if there's an offer on the table, maybe a plea bargain here?
Yeah, I mean, I would think that it's not necessarily inappropriate. You know, it's certainly interesting, right? You know, we're really going to see how much she really has here. And I guess if they're allowed to confer, if anything comes out of it, that's also going to be very telling about what was going on. Will our husband think that, or his counsel more appropriately think that, well, you know, he's better off going it alone. My sense is, you know, if they have some thought that they can get together and that could possibly help each of their lots, then they would be incentivized in terms of trying to put something together that way. But it's not clear as to how that will really come out or how much less confident this makes the prosecution about their presentation, about their case.